All right. This is Judge Eric Shepard, presiding judge in Travis County Court at Law Number 2. I'm calling this hearing to order in cause number D1GN21007-305, Bank of America versus Susanna Kazhainsik and Elena Yosifovna Shapiro. Today is Thursday, January 9, 2025. This hearing is being conducted remotely on Zoom and live streamed on the court's YouTube channel. No recordings of this hearing are permitted other than by the official court reporter. Any violations of these instructions are punishable by contempt of court. If you would announce yourselves for the record, tell me who you represent and whether you're the movement or respondent in today's hearing.
Your Honor, this is Laura Cabuto on behalf of Gitel Law, and the motion being heard today is mine.
Okay.
Your Honor, my name is Carson Henderson, representing Elena Shapiro in this matter. My colleague Nick Kennedy is also on this call or is also in this hearing as well, representing Ms. Shapiro. We are the respondent.
All right. Yes, ma'am. You may proceed.
I'm Mirjana Vizentin. I'm Mrs. Shapiro, European Counsel.
All right. Thank you. Ms. Cabuto?
Yes, Your Honor. As you may recall, we actually had a hearing on this motion back on August 1st of 2024 before you. This is probably the third or fourth hearing on this motion, but this is the second time that you have heard it. If you recall from that hearing, Your Honor, you heard arguments from both myself and Mr. Talavera. Mr. Talavera also had Ms. Shapiro present. My client, Ms. Gitel, was present. I think Ms. Vizentin was present as well. And the court instructed the parties that rather than taking taking any oral evidence at that hearing, that the parties were to submit affidavits regarding the facts and incidents that were being claimed to the court no later than August 30th. And then within 30 days thereafter, conduct any depositions that they felt were necessary in order to proceed forward with that hearing or with the determination on the motion. Your Honor, we did that. The court had those affidavits with supporting documentation on August 30th. I think Mr. Talavera submitted his a few days earlier. We have corresponded with Mr. Talavera's office about the fact that we did not need to proceed forward with depositions of Ms. Shapiro, Mr. Talavera, or Ms. Vizentin. I only mentioned Mr. Talavera because he also submitted an affidavit. I would not normally expect to depose an attorney. And Your Honor, as you're aware, it's been a couple of months since we actually heard oral arguments in this case. We asked that this motion be set for a hearing and determination again before the court. So because we've already heard the arguments of the motion, would you like me to go back through those, Your Honor? I just didn't want to waste the court's time.
Well, you might give me a brief thing. It's been a while since I slept in, but I mean, if you would just give me a little bit of overview. I think we have a lot of it. We all have it on record, but just as a reminder for this proceeding.
Very good. Your Honor, as the court may recall, Gitel Law was retained as counsel by Ms. Shapiro back in 2021. Ms. Gitel, Amy Gitel, was contacted by Ms. Shapiro's daughter, Susanna Kazansky, in October of 2021. She had previously done work with Ms. Gitel, and she contacted Ms. Gitel to attempt to see if there was any assistance she could give her in trying to release monies that had been deposited into the registry of the court or were about to be deposited into the registry of the court by Bank of America. Those monies are currently still sitting in the Travis County Clerk's office. At the time that they were deposited, it was in the amount of $6 million. Ms. Gitel contacted counsel for Bank of America, and his name just totally escaped me. I think he made an appearance before the court before. And he told her that the money was going to be deposited, that there was no way he was not going to deposit it into the registry of the court. I think the issue at that time was who was the rightful owner of those funds, because both Ms. Shapiro and Ms. Kaczynski were listed on the account.
Yes.
So Ms. Gitel began her work, and in December of 2021, after she had already started work for Ms. Shapiro, she entered into a fee agreement with Ms. Kaczynski and Ms. Shapiro. That fee agreement was a contingency-based fee agreement. In February, there were 2 hearings in front of Travis County judges. One was with regard to Judge Crump, who expressed some concern over the contingency fee agreement. And at the time, during that hearing, Ms. Jetel volunteered to change her contract to an hourly fee agreement. As things progressed in March and April and May of that year, well, let me back up. In February, the judge found it necessary to appoint an ad litem, which was Slav Talavera, to represent Ms. Shapiro's interests.
He had, if I recall correctly, he had some problems with that, how the contract got restructured.
Mr. Talavera, at the time that the contract was being restructured, Mr. Talavera's only concern, Your Honor, and this is in Ms. Jetel's affidavit as well as the exhibits we attached to the affidavit, his only concern was the dual representation between that Ms. Jetel had of Ms. Shapiro and Ms. Kaczynski. He did not express any concern about the fee agreement or the contingency fee agreement. In fact, he presented evidence to this court that he was fine with it.
Okay.
So Mr. Talavera was involved in February of 2022. In March and April, discussions continued amongst the parties. And I believe it was sometime in May, Ms. Shapiro expressed to Ms. Jetel that she no longer wanted her to represent her. So Ms. Jetel prepared withdrawal paperwork and presented that to the court. At one of the hearings in front of the court, Your Honor, and I think it was in May of 2022, again, it's addressed in the affidavit, Mr. Talavera specifically referenced the fact that the appropriate way for Ms. Jetel to get paid for her legal fees, which she had rendered over the past 7 months, was to file a petition to intervene into the case. Our motion that was filed back in December of 2023 references the case law, the Vincent and Elkins case, as well as the Wendell Turley case, which addresses this fact. The attorneys have the right to intervene into cases in order to recoup their attorney's fees for legal fees and legal services that have been provided. It was not until late last year, Your Honor, that Ms. Jetel was alerted in any manner through me that there was a dispute about when the contract began and what fees she was entitled to. More specifically, I think right before a hearing on this motion, I think it was within an hour, Mr. Talavera filed a motion with the court stating that the contract had not begun until May of 2022, and therefore Ms. Jetel was only to be allocated fees in the amount of a little over $7,000. This was after Mr. Talavera repeatedly had recognized that there was a contract in place prior to May of 2022. The reason I believe that he cited that particular date, Your Honor, is because that is when the hourly fee agreement was signed with Ms. Shapiro. Okay. Over the course of time, Ms. Shapiro has signed 3 contracts with Ms. Jetel. Sorry, Your Honor. The first one was contingency. The second one was hourly. And then the last one was hourly as well. So, Your Honor, we're presented here today. I think what Mr. Talavera intended to do on August 1st at the hearing with this court was to have Ms. Shapiro take the stand and present evidence. The court had asked me specifically if I had notice of that and if we were prepared to take that oral evidence from the 2 parties. I indicated that I had not been informed of that, wherein the court instructed us to go ahead and get affidavits and, if need be, take depositions before any witnesses were called to the stand in this matter. So that is where we left off, Your Honor. As my motion states, there's Texas case law to support Ms. Jetel's intervention into this case to receive the monies for payment for legal services. There's also support that she's entitled to have those monies paid out of the registry of the court. I received Ms. Shapiro's response to my motion on Tuesday. And I can either address those arguments kind of now, Your Honor. I filed a reply yesterday. or I can wait until Ms. Shapiro's new counsel has spoken. But this court in the past, in this matter, have paid not only Mr. Talavera out of the monies that are sitting in the court's registry as his work as an ad litem, they have issued payment to multiple translators who have been engaged in translating for Ms. Shapiro during the course of legal proceedings. So in this particular instance, this is a precedence that has been set. This is not an unusual practice. It also is expounded by the fact that Ms. Shapiro, because of her status with Interpol, with regard to claims of fraud that have been made against her, that is the whole reason that these monies got deposited into the registry of the court to begin with. Bank of America did not feel comfortable releasing $6 million to Ms. Shapiro because she had a red notice on Interpol on her. Therefore, Bank of America interpleaded these monies into the registry of the court so that Ms. Shapiro could come get them out with a court order. So these monies have been sitting here since then. We
And
only
you're asking the
interplead.
court to do what today?
Your Honor, what I'm asking you to do is just to issue payment for legal services for Jetel Law regarding the legal work that she did for Ms. Shapiro from October of 2021 until
2.1 million or two?
No, Your Honor, we submitted a detailed billing analysis
Okay.
that Ms. Jetel had, and it's a little bit over $80,000.
Oh, okay.
There's no contingency fee agreement anymore. It is hourly.
Okay.
And then my other requests, Your Honor, were for my attorney's fees for the almost 2 years I've had to work on this case for Ms. Jetel, as she has been having to pay me to try to recoup her legal fees.
Okay. Or is that it for now, or?
Yes, Your Honor. Thank you.
Go right ahead, sir.
Good afternoon, Your Honor, and may it please the court. Providing response in this case, Ms. Shapiro wants to acknowledge that the main dispute in this case is the original interpleader. The original interpleader that Bank of America pleaded as a petition in this case. That's for $6 million. Now, Ms. Cabuto just acknowledged that the reason for the interpleader is because Interpol had a red notice issued on behalf of Ms. Shapiro or for Ms. Shapiro. And Your Honor, that's not accurate, however. The petition in interpleader specifically states that the reason that Bank of America interpleaded the funds is over concerns over Ms. Kaczynski's power of attorney that she had provided to Bank of America in the context of whether or not that power of attorney was indeed a real power of attorney, such that it created a dispute over between Ms. Kaczynski and her mother as to who actually obtained rightful ownership of the funds. Bank of America may have taken into consideration Interpol's red notice, but they certainly didn't originally plead it. But that's not really the main issue here today, Your Honor. The main issue here today is that Ms. Shapiro has waited for approximately 6 years to receive $6 million that was in a checking account with Bank of America. The Bank of America interpleaded with the court around 3 years ago in 2021. Her daughter relinquished any claim to those funds in February 2022 by affidavit. And as such, Ms. Shapiro is the only rightful claimant left to those funds, which would leave really only one option for interpleaded funds, which is that because Ms. Shapiro is the rightful owner to those funds, she is indeed entitled to those funds and entitled to distribution of those funds, which is what we asked the court for today. This matter can be resolved today if the court does indeed allow the distribution of all of the $6 million to Ms. Shapiro. Now, moving
$1,000 that she claims is you're figuring, how does that work out, or what does that? How do the attorney's fees for both Ms. Cabuto and I forget the woman's name. Sorry,
Ms. Jetel.
Yeah, Ms. Jetel. Are you saying the 6 million minus those two amounts, or you're just saying the 6 million and they go fish?
Your Honor, the interpleader procedure is such that a breach of contract claim like the one that Ms. Jetel has filed against Ms. Shapiro is separate from the interpleader interest. I know that Ms. Caputo acknowledged that they had a justiciable interest in this. However, a justiciable interest by the cases that Ms. Caputo cited to is actually only a justiciable interest for contingent fee contracts that assert an interest in the ultimate recovery of the funds. Neither of these engagement agreements provide for that particular interest. As such, those funds, or what she's requesting is essentially, yes, Your Honor. What she's requesting as far as fees are is purely a breach of contract claim at that point, and has nothing to do with the fees that are in the court's registry, or the funds that are in the court's registry that are indeed Ms. Shapiro's. There's no genuine issue of material fact as to who the funds belong to. They belong to Ms. Shapiro, as proven by affidavit by Ms. Shapiro and by Ms. Kaczynski. And assertion of a justiciable interest really can only happen by contingent agreement that expresses that that particular attorney may have a lien or may have some sort of interest in a judgment or recovery at the end of the lawsuit, which is what those cases actually say. Really, Your Honor, what this is as well is a motion for payment of attorney's fees in this context has no basis in law. It has no basis in appellate precedent. It has no basis in for really any authority to provide for such without some form of motion for summary judgment or trial proceedings, which would be the way to dispose of this particular issue. And a genuine issue of material fact still exists even as to Ms. Jatel's claimed fees. She acknowledged on the record in February 2022 that her fees weren't entirely kept accurately, or that her time wasn't entirely kept accurately because she was originally on contingency. Well, the problem then comes in that, Your Honor, that she attempted to claim fees for October to December when she was representing both Ms. Kaczynski, or when she was only representing Ms. Kaczynski, apparently at the time. The engagement agreement wasn't signed until the end of December 2021, in which Ms. Shapiro only signed the signature page and did not speak with Ms. Jatel at that time. And then, Your Honor, she's also claimed fees for the purposes of her withdrawal motion as well, which we believe to be fees that were not incurred properly or were not billed properly. And so there are genuine issues of material fact as to the legitimacy of her billing records and whether or not the fees that were ultimately charged to Ms. Shapiro were fees that should be charged to Ms. Shapiro, both within the confines of our ethical duties as attorneys, but also because she was representing Ms. Kaczynski and Ms. Shapiro at the same time.
So you're asking for the $6 million to be released to Ms. Shapiro, and then if Ms. Shapiro or Ms. Caputo and her client need money, they need to file in the court for that and file a motion, and then you can have that conversation then. Is that what you're suggesting?
In a sense, Your Honor, more so what I'm suggesting is that because this was originally an interpleader procedure, that Ms. Shapiro be paid out the $6 million in funds based on that interpleader procedure. But the breach of contract claim that Ms. Jatel has filed on her own behalf, that has nothing to do with the interpleader procedure. That's an intervention as just a pure claim, almost that would operate as a counterclaim. So, for instance, Your Honor, let's say just for the sake of example that—
Well, how do we resolve the counterclaim?
By summary judgment or by trial proceedings. Either way, Your Honor, it's one of those that those types of cases that continues on after the fact.
Within the same cause number, or are you saying a separate one? Because if you're telling me give us the $6 million and then we'll resolve the counterclaim, the case isn't over until the counterclaim is resolved, right?
My understanding, Your Honor, is that the breach of contract claim would still operate under the same cause number as this particular cause because they intervened. Yes, Your Honor.
Okay. Anything else?
Yes, yes, Your Honor. Just continuing here, I just want to acknowledge a few things for the court. So Ms. Caputo made reference to Mr. Talavera and some of his recommendations as it relates to this particular case, right? And especially as it relates to Ms. Jatel's representation of Ms. Shapiro and Ms. Kaczynski, her daughter, at the same time. Now, the court originally had expressed significant discomfort with the fact that Ms. Jatel was representing Ms. Kaczynski and Ms. Shapiro at the same time. And Mr. Talavera even had expressed significant discomfort with that, which is why he suggested to Ms. Chattel that she withdraw from representation of Ms. Kaczynski and Ms. Kaczynski go and obtain her own counsel. Now, also, Mr. Talavera is not the court, so any recommendations that he has made to any of the parties in this particular matter are simply that. They're recommendations, they're not orders. And furthermore, Your Honor, in regard to payment of attorneys out of the court's registry, right? Paying an ad litem's fees out of the court's registry is a very reasonable thing for the court to do because an ad litem is an officer of the court. Same thing goes for the translators. These weren't necessarily paid out of the registry of the court in the sense that they were paid by Ms. Shapiro. They were paid as officers of the court. Ms. Chattel is not an officer of the court to the extent that she's not representing a private party in this matter. It did not represent a private party in this matter. Rather, Ms. Chattel is separate in the sense that she did represent a private party in this matter, Ms. Shapiro.
I just want to make sure I understand what you're suggesting, that the $6 million minus Ms. Caputo's attorney's fees might be all right, but not pay any money out of that $6 million to Ms. Chattel. Is that correct?
Oh, no, Your Honor. In fact,
Okay.
I don't believe that that the fees for Ms. Chattel or for Ms. Caputo are fees that Ms. Shapiro should be paying out of the court's registry at all.
Okay.
Yes, Your Honor. I believe that.
I just want to be sure.
Oh, certainly, absolutely, Your Honor. I appreciate the seeking for clarification. And Your Honor, really, at the end of the day, Ms. Shapiro has waited for approximately 6 years for this $6 million. And she's had to take a whole lot of hoops and jumps to be able to get it. She had counsel for a while, and that counsel, it does not appear represented her interests in the sense that she represented her interests above her own. Ms. Chattel withdrew from the representation and immediately filed a motion for payment of attorney's fees, which, Your Honor, doesn't necessarily indicate someone who was in fact taking Ms. Shapiro's interests at heart, which is also what our issue is with the fees that she's claimed. Is she prepared a motion to withdraw and engaged in withdrawal procedures and then turned around and billed Ms. Shapiro for it. She billed time for what she did for Ms. Kaczynski before she ever spoke to Ms. Shapiro. In fact, 4 months before she ever spoke to Ms. Shapiro. And Your Honor, the court, the reason this is even here at this point, the reason that this case has continued now almost 2.5, 3 years later is because the court was uncomfortable with Ms. Chattel's representation of both Ms. Kaczynski and Ms. Shapiro at the same time, as well as her contingency arrangement with Ms. Shapiro originally, which would have netted her $1.8 million out of the registry for what really amounted to essentially less than 100 hours of work. So at this time, Your Honor, we would request that Ms. Shapiro be distributed her $6 million as she is the rightful owner, that the fees that Ms. Caputo and Ms. Chattel are claiming be denied to them, and that they essentially follow proper procedure and engage in a traditional motion for summary judgment for those fees or for their breach of contract, or we go to trial, Your Honor.
Your Honor, may I add one additional point to the argument my colleague made on behalf of Ms. Shapiro?
Sure.
Very briefly. What we've got here, Your Honor, is Ms. Chattel and Ms. Caputo. They do have a claim for their attorney's fees. That claim is pre-judgment, right? What they are asking to do is issue a pre-judgment asset freeze to allow them to recover on a future judgment that they may obtain on that claim for attorney's fees. But we don't believe that is appropriate or authorized by the law. What we believe is appropriate is that the full $6 million be distributed to Ms. Shapiro because there is no dispute about the ownership of those funds. They may want to collect against those funds for a future judgment, but there's no dispute about the ownership. At a minimum, Your Honor, their claim, their potential judgment they may receive in the future for attorney's fees is $80,000. They're asking you to freeze $6 million for that claim. We don't believe there is any world where that's reasonable. So at a minimum, if this court is not prepared to adjudicate their claim today as zero, we believe the court should release either all of the funds or all of the funds minus the amount that they are seeking. I don't think they'll tell you they're seeking anything close to the 6 million, and thus there's no basis to hold up 6 million for a claim for 80,000, or even if you look at Ms. Kabuto's attorney's fees, which I haven't seen quantified, I can't imagine they're anywhere near the numbers we're talking about here. So we think at a minimum, all they are entitled to is a freeze over a portion sufficient to secure their potential future judgment, and the rest should be released to Ms. Shapiro.
Understood. Mr. Caputo?
Your Honor, the only thing before this court today is the motion to issue payment for attorney's fees. There is no other motion for the disbursement of these funds of the $6 million before the court. There is nothing else set for a hearing before this court. So I'm unclear how we get there today, or how I had noticed that new counsel for Ms. Shapiro intended to argue that today. Furthermore, as to my fees, as well as Ms. Jatel's, both of us submitted affidavits back on August 30th of 2024. I also submitted, I believe, redacted billing entries that quantify my fees. Your Honor, if I can ask, is the court, I'll just move on. Regarding Ms. Shapiro's claims that the appropriate remedy for Jatel Law is to go ahead and have the court release the $6 million and then have Ms. Jatel sue Ms. Shapiro. I'm unclear how that's going to happen and the jurisdictional issues that it presents, Your Honor. The two cases, I do not think that Ms. Shapiro is going to voluntarily submit herself to the jurisdiction in the United States. She is a resident of Israel and she is a Russian national. I do not believe that that is the correct remedy for Ms. Jatel to try to recoup her legal services or her fees for her legal services. As to the argument about whether or not Ms. Jatel performed services prior to December of 2021 when she was talking with Ms. Kaczynski, even Ms. Shapiro's new counsel filed a motion for summary judgment on January 7th in the evening, and attached to that motion for summary judgment is an affidavit from Susanna Kaczynski, Ms. Shapiro's daughter, that establishes that she is an attorney, in fact, for her mother. It was from February, might have been 2022 or even before that, Your Honor. There is no question here that Ms. Kaczynski had the power of attorney, or she could act as an attorney, in fact, for her mother. That is why Ms. Jatel was speaking with her. The contract being signed in December of 2021 is clearly just a contract that's being signed. Ms. Jatel's work started well before that.
What is the total amount of fee? Hold on. What is the total amount of fees that your side, whether it's Jatel or you, are we talking about? What's that amount of money?
Your Honor, as of August of 2024, my fees were a little bit over $22,000. They've probably obviously gotten a little bit higher since then, a little bit, not a ton. And Ms. Jatel wanted, I think it's $80,175, somewhere in there. Let me pull it up. It was not over 81,000.
So just over, I mean, okay, so about $100 and some odd $1,000.
Correct, Your Honor, a little bit over that, correct.
Okay. Real quickly, and I'll come back to you in just a second. Mr. Henderson, Ms. Caputo raises the point that you haven't asked in a motion of any kind to do ask for the release of this funds, and that the only motion before the day is the one for her and her client. Is that correct? Or you think that there's a different argument to be made?
Your Honor, I do believe there's a different argument to be made. While our motion to disperse funds is not necessarily set for hearing specifically today, Ms. Shapiro has at least 3 different motions to disperse funds on file before we were even retained as counsel. And we also filed the traditional motion for summary judgment and a motion to disperse funds the other night that requests that her funds be distributed. And while we understand that the court would have to engage in—
There's a bunch of hers here, so please tell me which her you're referring to.
Yes, Your Honor. Ms. Shapiro, our client. And Your Honor, what we We believe that because there has been as many motions to disperse as there have been before the court, and really the only thing that has held up the court from distributing the funds to Ms. Shapiro has been Ms. Jatel's claims for attorney's fees, that we believe today that Ms. Shapiro's funds should be distributed to her ultimately.
All right, Ms. Caputo?
Your Honor, I'm not sure where Mr. Henderson got several motions to disperse funds. As the court heard arguments back in August of 2024, prior to 2 other hearings, Mr. Talavera waited until 31 minutes before those hearings, and I think it was somewhere near that on another one, to file what he called a proposed disposition of issues. And those were 2 pages in length. Those were not set for hearings either, Your Honor, and they haven't been. The issue that the court has heard is this particular motion. And like I said, I think it's on the 3rd or 4th hearing.
Okay, so here's what I'd like you to do. Both of you send me your orders about what this case should come out of. Judge Shepard, Mr. Henderson, send me an order saying, Judge Shepard, I'd like for you to do this. Ms. Caputo, you're asking me to do that. I'll get those things in Word so that we can look over them and get and then let me go back through, which is a pile of paperwork, and let's see if we can sort out what needs to be done or I think needs to be done in this case. We may be close. We'll find out as soon as I get those drafts from you guys. All right?
Thank you, Your Honor.
Thank you, Your Honor.
In closing, may I make one additional point?
Sure.
I know I've done this once.
Almost out. Just when I thought we were out. Go ahead.
I haven't heard any opposition to the release of funds above and beyond the amount that they are seeking in attorney's fees. And I just want to make, I believe that's clear, that there is no claim asserted in these funds beyond the amount of attorney's fees they are claiming.
No, other than the amount of fees that Ms. Jatel is claiming, as well as the amount of fees I'm claiming, Ms. Jatel is not claiming that she's entitled to any additional monies. And I mean, Your Honor, I'm willing to talk to them and work this out. It's just Mr. Talavera and I could never get there.
Yeah, I'm happy to have you guys work it out and send me one order that needs to be signed. But if you don't think you can work it out, then just send me 2 and I'll work it out for you. But if you can work it out, given that just statement, which thank you, Mr. Kennedy, for bringing that up. I was kind of hoping we'd slide that under the radar, but that seems to me what exactly was going to happen or could happen as a potential deal. That's why I asked you to give me, both of you, to give me orders so I would know. If the order winds up being a joint order saying this is what I need, hallelujah. All right. Thank y'all.
Thank you, Judge.
Take care.
Thank you, Your Honor.
Bye-bye.